Hey, everybody, we're back with our third installment of our look into the Ripple Labs recent opinion issued by Judge Torres. And we're going to take a look at the analysis, which is the thing that everybody really wants to know more about. So let's get right into it. Okay, here we are, folks, at the top of page 14 of the Ripple Labs opinion. And yeah, you can see that there. And this is going to be a very important section for not only Ripple, but also other people and other companies that are in sort of the same position as Ripple. Because whatever reasoning is used here can be parroted in other cases, especially if someone else is doing essentially the same thing as Ripple. They can look to this opinion, which is public, and say, hey, Judge Torres decided it this way, new judge, you should also decide it the same way. So um, that is why this is going to be important. It's also going to be scrutinized in the appeal. Now, you might notice it's been a month or so since my last video on this opinion. And back then, I was absolutely certain that this was going to be appealed, and it was. And we'll get into that in a later video. And the reason for that is because Judge Torres, however she analyzes the facts, the Court of Appeals might find differently. So let's go through and see how Judge Torres uh, came to her conclusion. All right, let's read it line by line. Analysis: the XRP token. The plain words of Howey make clear that, quote, an investment contract for purposes of the Securities Act means a contract, transaction, or scheme. And she added that emphasis. That's why this little line is added there. But the subject of a contract, transaction, or scheme is not necessarily a security on its face. So she's saying that just because it's a contract, transaction, or scheme is not the end all be all of the analysis. We got to go a little bit deeper than that. Under Howey, the court analyzes the economic reality and totality of circumstances surrounding the offers and sales of the underlying asset. So this is another way of saying that we just have to look at what's actually happening and not just, oh, it's a contract, or oh, it's a transaction or a scheme, therefore it's a security. We gotta be a little bit deeper in our analysis. We can't just be so shallow. And she cites this case, which is a shorthand version of citing to a case she's already cited in the brief. Same thing with here, Glenn Arden. So if you want to know how to read these legal opinions and these citations, I will make another video specifically on this. And also, I discuss this in the first video on this topic. Okay. Howey and its progeny have held that a variety of tangible and intangible assets can serve as the subject of an investment contract. Fair enough. And Howey talks about orange groves. Glenn Arden refers to whiskey casks. Edwards is payphones. Hawking versus Du Bois from the Ninth Circuit refers to condominiums. Uh, Continental Marketing Corp versus SEC in 1967 talks about beavers. That's interesting. And SEC versus Telegram Group Inc. In 2020 refers to digital tokens. Okay, so all of these things can be the basis of investment contracts. In each of these cases, the subject of the investment contract was a standalone commodity, which is like an asset, like oil or sugar, etc. These are commodities, which was not itself inherently an investment contract, meaning the subject is a physical thing. Just because it's a physical thing doesn't mean it cannot be an investment contract. For instance, if the original citrus groves in Howey were later resold, those resales may not constitute investment contracts depending on the totality of circumstances surrounding the later transaction. Okay? Keep an open mind is essentially what she's saying. Here, the defendants argue that XRP does not have the character in commerce of a security and is akin to other, quote, ordinary assets like gold, silver, and sugar. And she cites exactly where Ripple makes that argument. This argument misses the point because ordinary assets like gold, silver, and sugar may be sold as investment contracts depending on the circumstances of those sales. So we have to look at how are these things being sold, not necessarily what are they. How are they being sold? And she cites Glenarden again, another case, Fidance versus Harris. And from that case, she quotes, plenty of items that can be consumed or used have been the subject of transactions determined to be securities because they had the attributes of an investment. Okay, so it's more about we're looking at how are these things sold. It's the gist of that. Even if XRP exhibits certain characteristics of a commodity or currency, it may nonetheless be offered or sold as an investment contract. As another court in the district recently held, and this is from the Telegram case regarding digital tokens, while helpful as a shorthand reference, the security in this case is not simply the digital token, the gram, which is little more than an alphanumeric cryptographic sequence. The case presents a scheme to be evaluated under Howey that consists of the full set of contracts, expectations, and understandings centered on the sales and distribution of the gram. Howey requires an examination of the entirety of the parties' understandings and expectations. Again, she's just hammering home that we're not looking at the thing that is being sold. We're looking at how it was being sold. Who was it being sold to? What did people believe at the time these things were being sold? It's a deeper analysis. Okay, XRP as a digital token is not in and of itself a contract, transaction, or scheme that embodies the Howey requirements of an investment contract. Rather, the court examines the totality of circumstances surrounding defendants' different transactions and schemes involving the sale and distribution of XRP. And again, this is all just sort of repeating the same thing, that we're not looking at XRP. That's where people get confused, is we're looking at how was XRP sold. And another citation here, Marine Bank versus Weaver, a U.S. Supreme Court case from 1982, and she quotes note 11, which is a footnote. Each transaction must be analyzed and evaluated on the basis of the content of the instruments in question, the purposes intended to be served, and the factual setting as a whole. Okay. Next section, defendants' offers and sales of XRP. So now she's moving into how was XRP sold. The parties cross-moved for summary judgment on the SEC's claim under Section 5 of the Securities Act. Whether defendants offered or sold investment contracts is a legal question that the court resolves based on the undisputed record. So what that means is this is something that essentially the court decides, that this is not something that will get submitted to a jury, which is the reason why they're able to seek summary judgment in the first place, because this is a legal question. And whatever she bases her analysis on, the facts under that have to be undisputed. If any fact that she uses to support her conclusion about investment contracts is disputed, oh my gosh, that's going to be an appellate worthy item, and the whole case could be kicked back down to the trial court in order to have an actual trial on that particular issue. So we better hope that she did not use any disputed facts in her opinion. Okay. SEC versus Thompson, 2013 case, whatever. The SEC alleges that Ripple engaged in 3 categories of unregistered XRP offers and sales: institutional sales under written contracts for which it received $728 million, programmatic sales on digital asset exchanges for which it received $757 million, and other distributions under written contracts for which it recorded $609 million in consideration and other than cash, like services and just other things. The SEC also alleges that Larson and Garlinghouse engaged in unregistered individual XRP sales from which they received at least $450 million and $150 million, respectively. That's a lot of money, but good for them. The court shall separately analyze and evaluate each category of transaction. Number 1, institutional sales. The court first addresses Ripple's institutional sales of XRP to sophisticated individuals and entities. We're talking banks. Okay, when she says sophisticated individuals and entities, banks, hedge funds, investment banks, I mean, basically everyone except you and me who are typically considered unsophisticated individuals by and large. I mean, it's an actual legal specification that I'm not going to get into. But when we're talking about institutional sales, just think the big guys, okay? Pursuant to written contracts. The SEC alleges that these institutional sales were distributions of XRP into public markets through conduits, and that some institutional buyers were buying XRP as brokers, while others simply resold it as part of their trading strategies. So that's what the SEC is saying. The first prong of Howey examines whether an investment of money was part of the relevant transaction. Okay? We're going into what does Howey say and how does it apply here? Here, the institutional buyers invested money by providing fiat or other currency in exchange for XRP. So they paid for XRP using dollar bills or British pounds or euros or whatever. Defendants do not dispute that Ripple received money for XRP through its institutional sales. So again, Ripple doesn't challenge the fact that they received fiat currency in exchange for its XRP through these institutional sales. However, defendants argue that an investment of money is different from merely payment of money. That's a cute argument. I'm not buying it. And let's see. That is how he requires not just payment of money, but an intent to invest that money. So it's not just paying for something. You have to pay for it with the intention that you're going to use it for investment. I don't buy that. And immediately the court also does not buy it. Not so. Defendant's purported distinction is not supported by the case law. I mean, that's just, again, that's Ripple trying to add elements to the Howey test, and the court's just not going for that. The proper inquiry is whether the institutional buyers provided the capital, put up their money, provided cash. That's all that's required to meet that portion of the Howey test. Defendants do not dispute that there was a payment of money, the court finds. Therefore, this element has been established. I think that's the right call there by the judge. The second prong of Howey, the existence of a, quote, common enterprise, may be demonstrated through a showing of horizontal commonality. And I don't really know what that means, but hopefully she will explain it, and it seems like she will. And this horizontal commonality concept is apparently explained in Revac versus SEC Realty Corp. From a case from 1994 in the Second Circuit. Horizontal commonality exists where the investor's assets are pooled and the fortunes of each investor are tied to the fortunes of other investors, as well as to the success of the overall enterprise. So if people are paying, this is my understanding of what she's saying. If people are paying money to get XRP and the success of XRP sort of relies upon the success of Ripple and other people's investment into XRP or payment into XRP will also be based upon the success of others who have purchased XRP. Essentially, there's a market. That's how I'm understanding this. If there's like a market for XRP and it's going to go up and down, and the up and down action, a price action of XRP can be tied to Ripple's actions, then that essentially forms horizontal commonality. Here we go. Horizontal commonality is a type of commonality that involves the pooling of assets from multiple investors so that all share in the profits and risks of the enterprise. And this is from a case called ATB Coin LLC, another cryptocurrency case. Here, the undisputed record shows the existence of horizontal commonality. Ripple pooled the proceeds of its institutional sales into a network of bank accounts under the names of its various subsidiaries. So all the money that Ripple obtained from these institutional sales were put into essentially one large bank account that was sort of subdivided using various subsidiaries and stuff. In reality, it was one large bank account. Although Ripple maintained separate bank accounts for each subsidiary, Ripple controlled all of the accounts and used the funds raised from the institutional sales to finance its operations. So the court's saying it doesn't matter that you use various subsidiaries. You control all the subsidiaries and you control all the money in that account. So it's essentially one large bank account. Defendants do not dispute that Ripple did not segregate and separately manage investor funds or allow for profits to remain independent. So Ripple's just acknowledging that they're really not fighting the facts, that's good. It's good for summary judgment, at least. And Ripple's accountants recorded all of its XRP related proceeds together. Okay, so in reality, Ripple accounted for all this XRP stuff in one large pool group. Further, each institutional buyer's ability to profit was tied to Ripple's fortunes and the fortunes of other institutional buyers because all institutional buyers received the same fungible XRP. By the way, we missed a footnote here, footnote 17, or what is that? Oh, 12, actually. The SEC also argues that the record establishes strict vertical commonality. The Second Circuit has not addressed whether the strict vertical commonality theory can give rise to a common enterprise. In this case, because horizontal commonality establishes the existence of a common enterprise, the court does not reach the issue of strict vertical commonality or its viability as a theory. So, what is she saying here is that there's an alternative argument that the SEC was making to establish a common enterprise, which is an element of the Howey test. And it's this vertical commonality concept, which the court's saying we're not even going to talk about that because the court has already found that horizontal commonality was established. And this is important really because she's not trying to make new law. The Second Circuit hasn't made a decision on strict vertical commonality, and she doesn't want to be, Judge Torres doesn't want to be the one to make it so that to establish vertical commonality, because then the Second Circuit will have a chance to strike down this opinion if they, for some reason, don't like her application of vertical commonality. So she's being safe here with this footnote, saying, I'm just not even going to talk about the vertical commonality theory. Okay, so each institutional buyer's ability to profit was tied to Ripple's fortunes because all buyers received the same fungible XRP. So again, that's basically, in my understanding, she's saying XRP is the same XRP that everybody else had. Like one person's XRP is essentially the same as someone else's. So it's there's a market for it, and the market will determine whether or not there's a success or a price action upwards or price action downwards. So everyone's in it together. And again, I'm not an SEC, I'm not a securities lawyer, so this is my ordinary lawyer's understanding of this stuff. Okay, so we have footnote 13. Let's see here. The court holds only that a common enterprise existed between Ripple and the institutional buyers. The court does not reach the question of whether the common enterprise extends to encompass other XRP holders, defendants Garlinghouse and Larson, the XRP ecosystem, or any other entities. So she's limiting her finding of a common enterprise to only the institutional buyers, which is important because this prong of the Howey test does not necessarily apply yet, at least, to the other identified targets of the sales that Ripple was making. So that could lead to a finding that essentially the Howey test was not met for these other types of buyers. Okay, and that was footnote 13. Okay. Ripple used the funds it received from its institutional sales to promote and increase the value of XRP by developing uses for XRP and protecting the XRP trading market. So she's saying this is how XRP tied the fortunes of all the investors together because they were actively trying to increase the value of XRP by developing uses for it or protecting the XRP trading market from big decreases in sales prices and that sort of thing. They had an active hand in the XRP price. When the value of XRP rose, all institutional buyers profited in proportion to their XRP holdings. Let's see. This is she's quoting she's quoting a case called KIK, a different case. The success of the ecosystem drove demand for the digital token KIN and thus dictated investor profits. And she's also citing the Telegram case, finding horizontal commonality, where the digital token purchasers possess an identical instrument, the value of which is entirely dependent on the success or failure of the TON blockchain. And the investors' fortunes are directly tied to the success of the TON blockchain as a whole. Yeah. I guess I'm not entirely sold on this idea, but I guess if Ripple is the only entity that is having a significant effect on the XRP market, okay, I guess that kind of makes a little sense. So let's move on. By the way, what she's doing here is she's relying on other cases. So she's being very safe by saying, hey, this is what other judges have found, and I am not going to rock the boat here. I'm just going to use their same reasoning and apply it here as well. So again, this is why these opinions are very important, because other judges and in other jurisdictions will use these cases to support their own findings in their own cases, and it just becomes sort of a self-perpetuating, uh, a self-perpetuating analysis or ruling. So that again, that's why these are important. Okay, the court finds the existence of a common enterprise because the record demonstrates that there was a pooling of assets and that the fortunes of the institutional buyers were tied to the success of the enterprise as well as to the success of other institutional buyers. Okay, so that's just a summary of what she was just talking about. She's saying, hey, there is a common enterprise here, at least with respect to the institutional buyers. The third prong of Howey examines whether the economic realities surrounding Ripple's institutional sales. Was there another footnote that I missed? 13. Oh, 14's here. Okay. The third prong of Howey examines whether the economic realities surrounding Ripple's institutional sales led the institutional buyers to have a, quote, reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others, citing United Housing Foundation Inc. versus Foreman. I'm not sure if that's the right abbreviation for that, but this is a U.S. Supreme Court case from 1975. And she cites to footnote 14. Howey contemplates that an investor is, quote, led to expect profits solely from the efforts of the promoter or a third party. However, the Second Circuit has held, so Howey's a Supreme Court case that states this: an investor is led to expect profits solely from the efforts of the promoter or a third party. That's what the Supreme Court said. However, the Second Circuit, so one level down, the Court of Appeals of the Second Circuit, has essentially expanded upon that by saying that the word solely should not be construed as a literal limitation. Rather, courts consider whether, under all the circumstances, the scheme was being promoted primarily as an investment or as a means whereby participants could pool their own activities, their money, and the promoter's contribution in a meaningful way. Now, I 100% disagree with the Second Circuit here. Solely is pretty explicit. And I don't think that there's really any room for interpretation on the word solely. But the Second Circuit is essentially saying F you to the Supreme Court and doing their own thing. And this was a case that was in 2008. And that's a really frustrating part about the practice of law is, you could disagree with the Second Circuit like I am, but you still have to follow what the Second Circuit has decided. And that's what she's doing here. She's saying that, hey, Howey's saying that you only need to be expected to earn profits from the efforts of a promoter or a third party. And the Second Circuit's saying, nah, we need to actually look at more than just those things. And that's what you got to do, at least in the Second Circuit. So let's continue. In this context, profit means an income or return to include, for example, dividends, other periodic payments, or the increased value of the investment. And she adds emphasis there. This is her basically saying this is what she believes is going to be important to the analysis, the increased value of the investment. The reasonable expectation of profits from the efforts of others need not be the sole reason a purchaser buys an investment. An asset may be sold for both consumptive and speculative uses. So you can still meet the Howey test even if you want to purchase XRP for consumption in addition to as a speculative asset. So even if you bought XRP because you were going to use it in, let's say, the XRapid or ODL use case, if you wanted to speculate on XRP, then it's going to meet this definition of a reasonable expectation of profits. That's how I'm understanding that. And that's a concept that was expounded upon in the SEC versus LBRY Inc. case from 2022. Continuing. Moreover, the inquiry is an objective one, focusing on the promises and offers made to investors. It is not a search for the precise motivation for each individual participant. So this is saying that we're not looking at what each individual was thinking at the time. We're kind of using this reasonable person thought. So you don't look at what actually happened. You kind of just, or what each person was actually thinking. You kind of just use this amorphous, reasonable person standard to determine it. And that's what allows the court to make this ruling essentially without having a trial because you're using this objective standard. That's a sort of a complicated legal concept, but let's move on from there. Based on the totality of the circumstances, the court finds that reasonable investors object in an objective standard, situated in the position of the institutional buyers, would have purchased XRP with the expectation that they would derive profits from Ripple's efforts. From Ripple's communications, marketing campaign, and the nature of the institutional sales, reasonable investors would understand that Ripple would use the capital received from its institutional sales to improve the market for XRP and develop uses for the XRP ledger, thereby increasing the value of XRP. So this whole paragraph is essentially supporting this her conclusion about the objective, reasonable investor and what they would have believed. Now, again, I know this can be a complicated concept for people to wrap their heads around, but we're looking at essentially what does common sense tell you? That's kind of my way of interpreting what an objective standard means. If anyone, like not anyone in particular, but if just any investor that you could think of in your own head had been subjected to Ripple's communications, the marketing campaign, sort of the context of the institutional sales, I mean, would that fictional person in your head, this fictional ordinary person and an ordinary investor, what would they have thought? And the court saying that fictional person would have believed that they were going to be led to have an expectation of profits by investing in XRP in this way. And that meets the standard. So let's move on. That's what she's concluding. Starting in 2013, Ripple marketed XRP to potential investors, including the institutional buyers, by distributing promotional brochures that touted XRP as an investment tied to the company's success. So again, she's about to just keep going into examples of why the objective standard is met here. For instance, in the deep dive brochure, which was circulated to prospective investors, Ripple explains that its business model is predicated on a belief that demand for XRP will increase, suggesting that you can make profits. If the Ripple protocol becomes widely adopted and if the Ripple protocol becomes the backbone of global value transfer, Ripple expects the demand for XRP to be considerable. Again, suggesting you can make profits if you invest in XRP, if you buy XRP. Similarly, the Ripple Primer states that Ripple hopes to make money from XRP if the world finds the Ripple network useful. The Gateways brochure also explains that Ripple's business model is based on the success of XRP and includes a graphical representation of Bitcoin's price change below the text, "Can a virtual currency really create and hold value?" Bitcoin proves it can. So if Bitcoin can do it, so can XRP. Again, all of this is just examples that apparently are undisputed that um, Ripple was suggesting to people that you can make money with XRP. Later, through its XRP market reports, Ripple continued to connect XRP's price and trading to its own efforts. Ripple's Q1 2017 XRP market reports. Wait, did I miss a footnote? Just want to make sure. No, I did not. Okay. Later, through its XRP market reports, Ripple continued to connect XRP's price and trading to its own efforts. Ripple's Q1 2017 market report states that the company's efforts, including its vocal commitment to XRP, the announcement of a new business relationship, and continuing to sign up banks to commercially deploy its enterprise blockchain solution and join its global payments network, may have had an impact on XRP's price increase and impressive trading volume. So this is Ripple telling the public, hey, we are really getting some traction in the XRP price, and this through our efforts. Again, it's not good for meeting the Howey test. I mean, that is suggesting that the Howey test will be met. So not good for Ripple in that instance. The Q2 2017 XRP market report highlights XRP's dramatic and stunning price increase and notes that the market responded favorably to Ripple's escrow and decentralization announcements. Again, just more connecting the dots. I mean, this is from Ripple's own words. Ripple's Q1 2020 XRP market report states that XRP's liquidity was bolstered through new use cases for XRP outside of cross-border payments. Again, Ripple saying that, hey, our efforts are having an impact. During this time, Ripple's senior leaders echoed similar statements on various public channels. In a February 2014 interview, Larson said, quote, "For Ripple to do well, we have to do a very good job in protecting the value of XRP and the value of the network." So suggesting that Ripple can affect the value of XRP, and ask potential investors to give Ripple time to add the most value to the protocol. Again, suggesting Ripple can do something about the XRP value. In July 2017, David Schwartz, who was then chief cryptographer at Ripple, wrote on Reddit that Ripple's interests closely, but yes, not perfectly, align with those of other XRP holders. So yeah, this is all just continuing support. I'm going to just breeze through this. In February 2018, Schwartz posted on Reddit that what really sets XRP apart from any other digital asset is the amazing team of dedicated professionals that Ripple has managed to amass to develop an ecosystem around XRP. In December 2017 interview, Garlinghouse stated that XRP gave Ripple a huge strategic asset to go invest in and accelerate the vision it sees for an internet of value. And in March 2018, Garlinghouse said at a press conference that Ripple is very, very interested in the success and the health of the ecosystem and will continue to invest in the ecosystem. Ripple and its senior leaders publicly emphasized the complexity of creating an internet of value and the need for extensive capital to solve this trillion-dollar problem. Again, this is just over and over and over again, more support that Ripple was telling investors, you can make money with XRP, and we can help with that. For instance, in October 2017, Garlinghouse declared in a YouTube video, "I have no qualms saying definitively if we continue to drive the success we're driving, we're going to drive a massive amount of demand for XRP because we are solving a multi-trillion-dollar problem." In July 2017, Schwartz wrote on Reddit that Ripple can justify spending $100 million on a project if it could reasonably be expected to increase the price of XRP by 1 penny over the long term. Hey, I That's actually really interesting, um, but doesn't help their argument. But it's just on its face. That's cool. In November 2017, Schwartz posted on XRP chat that Ripple would use its war chest to put upward pressure on XRP's price. Haven't seen that quite yet, guys, over there at Ripple, but that's nice. It's pretty cool. These statements and many more are representative of Ripple's overall messaging to the institutional buyers about the investment potential of XRP and its relationship to defend its efforts. Clearly, again, this is just a summary of what she just said. I mean, she's saying there's even more things that we're not even talking about here. Okay, are representative of Ripple's overall messaging to the institutional buyers about the investment potential of XRP and its relationship to defend its efforts. Clearly, the institutional buyers would have understood that Ripple was pitching a speculative value proposition for XRP with potential profits to be derived from Ripple's entrepreneurial and managerial efforts. Further, the nature of the institutional sales also supports the conclusion that Ripple sold XRP as an investment rather than for consumptive uses. In their sales contracts, some institutional buyers agreed to lockup provisions or resale restrictions based on XRP's trading volume. So what she's saying there is that, even if you could use XRP for ODL, for example, or for, just any other consumptive use, like you're using up XRP for something other than speculation, well, Ripple's contract said you can't even use XRP for a certain period of time, or you can't resell XRP for a certain period of time. So that's leaning more towards, hey, you're buying XRP for speculation, not for usage, and you specifically acknowledge that, at least for a period of time. These restrictions are consistent with the notion that XRP was used as a currency or for some other consumptive use. I get that. I mean, that makes sense. If you're being told you can't use XRP for a period of time for consumptive uses, well, then you're not buying it for consumptive use. So, okay. Simply put, a rational economic actor would not agree to freeze millions of dollars if the purchaser's intent was to obtain a substitute for fiat currency. 100% agree with that statement. That makes sense. Certain institutional sales contracts require the institutional buyers to indemnify Ripple for claims arising out of the sale or distribution of XRP. And other contracts expressly stated that the institutional buyer was purchasing XRP solely to resell or otherwise distribute, and not to use XRP as an end user or for any other purpose. I think this is all pretty self-explanatory. These were being used for speculation, period. These various provisions in the institutional sales contract support the conclusion that the parties did not view the XRP sale as a sale of a commodity or a currency. They understood the sale of XRP to be an investment in Ripple's efforts. I agree with this conclusion. Seems like a common sense conclusion. Therefore, having considered the economic reality and totality of circumstances surrounding the institutional sales, the court concludes that Ripple's institutional sales of XRP constituted the unregistered offer and sale of investment contracts in violation of Section 5 of the Securities Act, which that's just not a good ruling for Ripple. But let's see what footnote 15 says. The court holds only that Ripple's sales of XRP to the institutional buyers were offers and sales of investment contracts. Okay. So only to the institutional buyers. To the extent the SEC instead argues that Ripple actually sold investment contracts to the public and used the institutional buyers as underwriters, I can't even believe the SEC made that argument. That's bonkers, to use a British term. That's crazy. I just don't believe that. The court rejects that argument. Good, because that's a dumb argument that the SEC made there. Really dumb. Now, this is becoming a long video. This is a long opinion. Let me just briefly see if we have enough time to go through this. Yeah, I think we can get through that. Okay. Programmatic sales. The court next addresses Ripple's programmatic sales. So these are the sales that they were making to the market in an algorithmic way, which occurred under different circumstances from the institutional sales. So this is different from what we were just talking about. The SEC alleges that in the programmatic sales to public buyers, so essentially to people on exchanges, on digital asset exchanges, Ripple understood that, quote, people were speculating on XRP as an investment. Yeah. Explicitly targeted speculators and made increased speculative volume a target goal. That's what the SEC is arguing. I agree with this. I mean, they understood that we as buyers on the market were trying to speculate. We don't have access to ODL typically as a retail buyer. So yeah, okay. Having considered the economic reality of the programmatic sales, the court concludes that the undisputed record does not establish the third Howey prong. Whereas the institutional buyers reasonably expected that Ripple would use the capital it received from its sales to improve the XRP ecosystem and thereby increase the value of XRP, programmatic buyers could not reasonably expect the same. I don't know if I agree with that, but let's read on. Maybe she'll change my mind. Indeed, Ripple's programmatic sales were blind bid-ask transactions. The programmatic buyers could not have known if their payments of money went to Ripple or any other seller of XRP. Okay, so she's saying here that just because Ripple was selling to the market using these programmatic algorithms, programmatic sales, that doesn't necessarily mean that the buyers knew that they were buying directly from Ripple. Okay, fair. Since 2017, Ripple's programmatic sales represented less than 1% of the global XRP trading volume. Okay, so the programmatic sales didn't even account for that much of the trading volume. Therefore, the vast majority of individuals who purchased XRP from digital asset exchanges did not invest their money in Ripple at all. They weren't giving any money to Ripple. 99% of people were not giving money to Ripple. Fair enough. And an institutional buyer knowingly purchased XRP directly from Ripple pursuant to a contract. But the economic reality is that a programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or what it was paying its money. Okay, I can understand that argument that although maybe people in the market that were buying XRP were buying it for speculation, they didn't necessarily know whether or not they were buying it directly from Ripple. So, okay, I can buy that. My mind has now changed. Further, it is not enough for the SEC to argue that Ripple explicitly targeted speculators or that Ripple understood that people were speculating on XRP as an investment, because a speculative motive on the part of the purchaser or seller does not evidence the existence of an investment contract within the meaning of the Securities Act. I don't understand that completely. Let's see. A speculative motive on the part of the purchaser or seller does not evidence the. Okay, I guess it just is suggesting that just because the buyer wants to speculate doesn't mean that that translates into an investment contract. I guess it kind of depends on what both parties were thinking. I don't know. Let's see what she says here. Oh, by the way, let's look at footnote 16, which is right here. Previous statement. The court does not address whether secondary market sales of XRP constitute offers and sales of investment contracts because that question is not properly before the court. Okay, so she's saying that as between us, like not Ripple, market sales that don't include Ripple at all, so secondary market sales, do those offers and sales constitute an investment contract? She's saying we're not even going to get into that question because that hasn't been presented to the court as a question that needs to be answered. Whether a secondary market sale constitutes an offer or sale of an investment contract would depend on the totality of the circumstances and the economic reality of that specific contract, transaction, or scheme. There's millions of transactions that are occurring, presumably, and we're not going to look into the totality of the circumstances because each person might have different motivations, might have different economic situations, and reasons for buying XRP. Hey, that's a really in-depth analysis. Let's not even go there. That's what she's saying. Good for her. Okay. Let's move on. Anyone who buys or sells, for example, a horse or an automobile, hopes to realize a profitable investment. But the expected return is not contingent upon the continuing efforts of another. Okay, so yeah, you can buy or sell a horse or an automobile or whatever, but let's say you bought okay, let me see if I understand this. If you bought a car from someone, yeah, you might hope that the value of the car increases, but that is not, you're not necessarily hinging all of your bets on whether the manufacturer of that car uh, does something to increase the value of that car itself. Hey, again, I'm not a securities lawyer, so don't hold me to this one. I'm learning just like you guys. Okay, the relevant inquiry is whether this speculative motive derived from the entrepreneurial or managerial efforts of others. Okay, so they're saying, hey, I want to speculate on this asset as a just someone here like us buying XRP. We don't think that that is going to be derived from the entrepreneurial and managerial efforts of others. We think it's just generally the market forces or whatever. It may certainly be the case that many programmatic buyers purchase XRP with an expectation of profit, but they did not derive that expectation from Ripple's efforts, as opposed to other factors such as general cryptocurrency market trends. Okay, yeah. Particularly because none of the programmatic buyers were aware that they were buying XRP essentially directly from Ripple. So that's fair. They didn't have any knowledge that they were buying directly from Ripple. So how could they possibly know that their XRP that they bought from Ripple was going to be influenced by Ripple's actions, as opposed to just the general market forces? Of course, some programmatic buyers may have purchased XRP with the expectation of profits to be derived from Ripple's efforts. However, the inquiry is an objective one, focusing on the promises and offers made to investors. It is not a search for the precise motivation of each individual participant. So again, she's relying on the reasonable person standard, this mythical, fictional investor, to make this analysis. So she's saying, hey, even if some people who bought XRP directly from Ripple had the idea in their heads that my value of XRP is going to increase based on what Ripple does, that's not what necessarily a reasonable person would have thought. So in this instance, this objective standard is to Ripple's advantage. Here, the record establishes that with respect to programmatic sales, Ripple did not make any promises or offers because Ripple did not know who was buying the XRP, and the purchasers did not know who was selling it. In fact, many programmatic buyers were entirely unaware of Ripple's existence. So some people who bought XRP didn't even know Ripple was a thing. They just heard about XRP and were like, yeah, I want to buy that. That's not an altogether unreasonable statement there. So she's hinging her entire argument about XRP, her conclusion about XRP's programmatic sales, on the fact that people did not know that they were buying directly from Ripple. I am persuaded by that. The programmatic sales also lacked other factors present in the economic reality of the institutional sales, which cut in favor of finding, quote, a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. For instance, the programmatic sales were not made pursuant to contracts that contained lockup provisions, resale restrictions, indemnification clauses, or statements of purpose. So she's saying, hey, this is just not the same thing as the institutional sales, where everyone knew we're going to be doing this for speculation specifically. Similarly, Ripple's promotional materials, such as the Ripple Primer and the Gateways brochure, were widely circulated amongst potential investors like the institutional buyers. So Ripple gave these specific promotional documents to these institutional buyers, but there is no evidence that these documents were distributed more broadly to the general public, such as XRP purchasers on digital asset exchanges. Yeah, so if you were going to go buy XRP from a digital asset exchange, did every time that happened, did Ripple send you some promotional material so you can read it before you bought it? No, obviously not. So, nor is there evidence that the programmatic buyers understood that statements made by Larson, Schwartz, Garlinghouse, and others were representations of Ripple and its efforts. I agree with this. Lastly, the institutional buyers were sophisticated entities, including institutional investors and hedge funds. So these are smart people. An examination of the entirety of the parties' understandings and expectations, including the full set of contracts, expectations, and understandings centered on the sales and distributions of XRP, supports the conclusion that a reasonable investor situated in the position of the institutional buyers would have been aware of Ripple's marketing campaign and public statements connecting XRP's price to its own efforts. Hey, these institutional buyers, they make smart, informed decisions. Everyone else, us heathens over here in the general world, we do not make smart, informed decisions. I hate this argument, but okay. There is no evidence that a reasonable programmatic buyer who was generally less sophisticated, aka dumb, as an investor, shared similar understandings and expectations and could parse through the multiple documents. She's saying that, hey, most people are generally too dumb to read these documents and understand them. God, that is so condescending. But fair. I don't know if that's what that's based on, but sure. Which includes statements sometimes inconsistent across many social media platforms and news sites from a variety of Ripple speakers with different levels of authority over an extended 8-year period. God, that is so annoying. Therefore, having considered the economic reality and totality of circumstances, the court concludes that Ripple's programmatic sales of XRP did not constitute the offer and sale of investment contracts. Footnote 17. Because the court finds that the record does not establish the third Howey prong as to the programmatic sales, the court does not reach whether the first or second Howey prongs have been satisfied. So she's saying, hey, I'm not going to engage in the full analysis. I'm only going to stop here because we've already proved that Howey is not satisfied. And I mean, frankly, the other two prongs were essentially admitted by Ripple. So that's not even a big deal. All right. So the next section here is other distributions. And gosh, this is becoming a long video. Let's do it. Let's just knock this one right out so we can put a bow on it. Other distributions. The SEC's last category of XRP offers and sales are other distributions under written contracts for which Ripple recorded $609 million in consideration other than cash in its audited financial statements. These distributions included distributions to employees as compensation and to third parties as part of Ripple's Spring initiative to develop new applications for XRP and the XRP ledger. The SEC alleges that Ripple funded its projects by transferring XRP to third parties and then having them sell the XRP into public markets. The other distributions do not satisfy Howey's first prong, that there be an investment of money as part of the transaction or scheme. Okay. She's saying, hey, these people did not provide money, services, or whatever else they were providing. That's not money, so that does not meet Howey's first prong. Howey requires that a showing that the investors provided the capital, put up their money, or provided cash. In every case, finding an investment contract, the purchaser gave up some tangible and definable consideration, which means something that you give in exchange, in return for an interest that had substantially the characteristics of a security. Here, the record shows that the recipients of the other distributions did not pay money, like cash, or some other tangible and definable consideration. Tangible means something you can physically put your hands on. To the contrary, Ripple paid XRP to these employees and companies. Okay, so Ripple paid XRP to these employees and companies. And as a factual matter, there is no evidence that Ripple funded its projects by transferring XRP to third parties and then having them sell the XRP. Like, essentially, that Ripple intended that to be some sort of middleman transaction. and then Ripple would somehow get the money from the middleman. Because Ripple never received the payments from these XRP distributions. Exactly. That's just a silly argument. In its opposition papers, the SEC pivots and argues instead that the other distributions were an indirect public offering because the parties that received XRP from Ripple, such as an Xpring recipient, could transfer their XRP in exchange for units of another currency, goods, or services to another holder. So the SEC is essentially, moving the goalposts here and saying, well, those people could have sold XRP and gotten money. Again, that doesn't really make sense. But the SEC does not elsewhere allege that the recipients of these other distributions, like Ripple employees and Xpring third-party companies, were Ripple's underwriters. Dumb argument. In any event, the SEC does not develop the argument that these secondary market sales were offers or sales of investment contracts, particularly where the payment of money for these XRP sales never traced back to Ripple, and the court cannot make such a finding. Therefore, having considered the economic reality and totality of circumstances, the court concludes that Ripple's other distributions did not constitute the offer and sale of investment contracts. And footnote 18, because the court determines that the record does not establish the first Howey prong as to the other distributions, the court does not reach whether the second or third Howey prongs have been satisfied. And again, she's just saying, hey, I've already determined that Howey is not applicable here, so let's end the analysis for this category of transactions. Okay, this video is now getting really long, so I'm going to end it here. We still have Larson's and Garlinghouse's offers and sales to get through and the rest of the opinion. But so far, that's two of the categories that the court has found in favor of Ripple and one in favor of the SEC. And that's actually not a terrible outcome so far. So let's see what happens next in the next video, which I will be recording right after this one. So stay tuned. All right, folks. Thanks for being here.